Welcome to the Zealous Advocate Podcast. Join attorneys James Moore, Kevin Littlejohn, and Misty Blagg as they explore law, technology, and persuasive arguments. Sit back, relax, and listen to your zealous advocates.
Hello, everybody. Welcome. We're so happy to have you here on the Zealous Advocate. I am Misty Blagg, healthcare attorney here at Shipman and Wright, and I am joined by my co-hosts, Kevin Littlejohn and James Moore. We're happy to have you on this journey that every advocate has to embark upon in improving their advocacy skills, and we hope to share with you some tips and tools and different techniques and explore different types of advocacy and different styles of advocacy. I would like to introduce you to Kevin Littlejohn, attorney here at Shipman and Wright, and I'll turn it over to Kevin to tell you a little bit more about himself.
Thank you, Misty. Good morning, afternoon, or evening to those that are viewing this. My name is Kevin Littlejohn II. I am, as Misty stated, an associate here at Shipman and Wright, and work primarily as a civil litigator with the firm. I've been at the firm for a little over 2.5 years now, believe it or not. I know I'm aged fast, James, from the moment that you met me.
Yes, you have.
But I've had the pleasure of working with these two fine attorneys and also being able to consider them both my friend. But I have to introduce someone that's very special to me. My supervising attorney, my mentor, my confidant, and my quote-unquote gym partner, but a great friend of mine, James Moore. I'll let you introduce yourself, James.
Kevin, I certainly appreciate that. First, to Misty, I certainly echo Kevin's remarks in terms of the introduction. It's an honor and privilege to not only have an opportunity to work with you both in the legal profession, but to share this experience together, this podcast. And I'm excited for that opportunity. Kevin, I certainly appreciate the kind words. And
they won't be often.
And for the most part, I think the feelings are mutual.
Right.
In terms of me, I've been practicing law now for 15 years here at Shipman and Wright, here in Wilmington, North Carolina, where I was born and raised. I've had an opportunity to represent some of the best clients and work with some of the best lawyers. And the two of you are no exception. About me, I primarily am a litigator. I've been doing that for the past 15 years, but in addition to that, I've had the opportunity, the privilege of acting as general counsel for several of our clients and for several of the various companies, entities here in the Wilmington area. So that's been a pleasure as well. In addition, Kevin and I, we are certified NFL sports agents. So throughout this process, hopefully we will be able to share with you guys those experiences as well. Misty, she is our newest lawyer that has joined the Shipman and Wright team. But she is probably one of the brightest, and since being here, she's certainly been a valuable asset for this team and for this firm. So, Misty, I'm going to turn it over to you now to talk a little bit about yourself.
Oh, my goodness. I'm blushing now, James. Well, thank you for that. I am a little bit different here at this firm. I'm a healthcare attorney. I'm starting a small healthcare practice area. I am a second career advocate. So I spent my whole first career, 20 plus years in healthcare, working as a dental hygienist and then a healthcare compliance investigator. So I'm really fortunate to bring all that industry knowledge into the practice of law. But I am learning day by day from Kevin and James, and in the spirit of that, James, I want to go back to you real quickly and just. You've had such a great career in litigation. I want you to talk about that one skill that you've developed, that's your go-to skill, that it really helps you define yourself and win cases.
That's a great question, great thought. I think it's two parts, and it comes down to confidence and I think persuasiveness. Coming out of law school, you certainly have a foundation of what the practice of law is, what it's all about. But until you start actually experiencing real world problems, issues, representing real clients, you don't realize the other things that are necessary to be, at least I'm not going to call myself a great lawyer yet, but to be able to practice law in the way that you want to. One of those things is confidence and persuasiveness, whether it's in the courtroom or whether you're just simply in a meeting with a client. You've got to be confident in the message that you are presenting and the advice that you are giving to a judge. It's in your argument. Are you confident in what you're telling the judge? Are you confident in the legal argument that you're making to a jury? You have to be confident to them, to express yourself, to make them think or know that what you're saying is true and that you believe it 100%. And then in a meeting, people are coming, clients are coming to you for advice on issues, situations that they need help with. So you better be confident in the advice that you're providing to them, because if you're not confident in yourself, how is the client
Amen.
going to be confident in you?
Confidence starts with you, right?
That's right.
It's
100%.
a personal conversation you have to have with yourself. But I have to tell a funny story now. Well, for Kevin, I went to law school with Kevin because, of course, I was second career, and I remember getting ready for trial advocacy and asking Kevin, Kevin, are you nervous? And he looks at me. He says, Misty, I'm just a naturally confident person.
Well, and to that point, Misty, there is a fine line between confidence or cockiness or arrogance. And you need to find that as a lawyer, because the last thing you want to do, even with opposing counsel, you don't want to come across arrogant, because, especially in a case, you're going to have to deal with each other for a long time. Mm-hmm. Yeah. So you can be confident without being cocky, without being arrogant to opposing counsel, to a jury, or even to a judge.
That is absolute truth. Now, Kevin, you did a lot of mock trial. You were on trial team in law school. Tell us about how that really slingshotted your career into litigation once you got into practice.
Yeah, I think the profession, the legal profession, along with a couple other professions, are very, very difficult to simulate in school and in a learning environment. But one of the best tools that I found while I was in school was the moot court mock trial advocacy program at Campbell School of Law, because I always sort of knew that I would be taking this journey towards civil litigation, but I wanted to really understand what exactly I was getting myself into. And I understood substantively what the law would be like, and sort of procedurally the mechanics of proceeding through trial may look like, but I had no idea what it would feel like from an emotional and mental and tactical standpoint. And so I would think one of the major benefits for me in participating in the mock trial program was being able to understand the things that you've got to think about aside from the law, whether it be how you present yourself to a jury, whether it be what you think resonates well to a judge as he's making rulings on certain objections, whether it be deciding which exhibits you think best portray the message you're trying to present at the end of the day. And you do all those things under this time crunch. And it is such a condensed span of time that you're doing it in law school that it gives you almost the same sense of pressure without the malpractice possibilities that you will face as an attorney. So you get a chance to deal with all of those different pressures under this condensed amount of time and learn how to do it with a team. And I think we'll all agree that successful attorneys, successful cases get tried, successful cases become won based upon how well the team was able to work to reach a resolution.
That's right.
And it taught me all of those. Yeah.
Well, I want us to each really talk about what they love about advocacy. And I'll start with me. I really love advocacy because we all advocate in our daily lives. As a mom, I have a dyslexic son, and I have to go and advocate in the school system. we do it in our daily lives, whether you're a lawyer or not.
Right.
And even if we're writing that letter to a company whose product has let us down, if we learn some key advocacy skills, we can really really raise our chances of getting the outcome that we want to see. How about you, James?
I agree 100%. I mean, this is a thing in everyone's everyday life where you are advocates for someone. So just because we all are lawyers talking about advocacy and typically relate that to the courtroom, we're advocating on so many other levels, just
Right.
in life and as lawyers. And it becomes so important to everyone because, I think everyone sitting in this room has someone that probably in the past 2 or 3 days they've had to advocate for outside of being a lawyer, whether it's in the school system.
With my HOA.
That's right. Yeah, or
With my mom.
or the cable company that keeps jacking up your price every other week.
Yes.
But no, so it's so important, and I think that's important for our listeners to understand that it is about all aspects of advocacy and not just the courtroom. And that's hopefully the message we get across to everyone, and they enjoy this process.
Kevin, do you have a particular area in advocacy that you feel like you enjoy more than another?
And because I'll be sort of long-winded in my response. But I'll
Please
try to
don't.
keep it short. I know you want me to keep everything short, and it probably keeps me safe to speak short. So we know I love oral advocacy. James oftentimes tells me you can love oral advocacy all you want, but you don't get there unless you first can write it well enough.
Wow, that's
And-
powerful
right.
words from your
And
mentor.
so
Appreciate
I
that.
say I am comfortable to a point of enjoyment with oral advocacy, but I enjoy the challenges of developing myself as a written advocate. When I see certain, James's writing style, things of that sort, that really gets me hungry to grow.
It's definitely an evolution.
Yeah, for sure.
So what's the dumbest mistake you've ever made in a case? It's just simple. I mean, it doesn't have to be earth-shattering. I'll tell you mine. Here's a lesson to all you young lawyers out there. Let your paralegal do the e-filing. They are better at it. Well, my lovely paralegal was on vacation, and I thought, well, I am not going to bother her on her vacation because, number one, she would not be happy with me. And I need her to always be happy with me. So I said, I can do this. I can e-file my own petition. So what do I go and do? I enter in all the information right, and then I upload the wrong document, which
my.
precedes me rapidly calling the clerk
my.
saying, please don't let it through. Well, it went through, and then I had to file an amended petition with the right document.
I've got a courtroom experience that is at least my most embarrassing. It was one of the first motions that I had ever argued in court, and it was calendar call. It was on a Monday. This was Brunswick County. The courtroom was packed with lawyers. I'd say there's probably 70 to 80 different cases on the docket, standing room only in the back. And the judge starts going through calendar call where he's calling every case, and then the lawyers are answering on behalf of plaintiff, on behalf of defendant. They're identifying themselves, and then they're telling the judge what the motion is and how long they thought it would take to have it heard. So, given this was the first time I had been in court, I was listening to all the lawyers stand up and present their case and tell the judge who they were, etc. And finally, my matter was called. And I stood up. I said, Judge, my name is James Moore. I'm here on behalf of the plaintiff. This is my motion. This motion should take 10 or 15 minutes. He goes, thank you, Mr. Moore. What bar are you from? Well, that's the first time I'd heard the judge ask this question. And I look around and I say, Judge, I'm from the North Carolina bar. The whole place just started laughing hysterically at me. And the judge just shook his head and he said, "Mr. Moore, what county?" I said, "Judge, I apologize. New Hanover County." And I didn't even want to argue after that because of how embarrassing that was. But look, I'll never forget it.
That's what I'm saying. Mistakes teach you more than successes.
That's right.
And you'll never make that mistake. Like, I'll never try to file my own document again.
That's right.
Certainly.
How about you, Kevin? Did you think about one? I mean, you just, you're excellence in all right. So you may not have made one.
I have made so many mistakes that James has laughed at over my years here. I have mistaken the judge for a simple lawyer and talked to the judge in the jury box for extended periods of time as if she was just a simple lawyer, and she stood up from the jury box and walks back and comes back out in the robe, and I knew immediately that she would never forget who I was.
Kevin, I have the best one. I'd like you to talk about this quickly, and that's in the back of chambers when you were.
Oh yes. So this was terrible. So I was again, I'm still a new lawyer, but I was really new at this point in time, and I was working on a different issue. My actual hearing had resolved, but they have all these judges' chambers behind the courtrooms in our local courthouse, and some of them, as you're back there, say jury room, and then the others are empty, and they say nothing on the nameplate. So I find one of these rooms that has nothing on the nameplate, and I go in there because I had a Zoom call that was starting that I wouldn't be able to get back to the firm for. So I set up back there in the chamber room, close the door, lock the door. Going through the call, probably about 10 minutes in, I hear a knock on the door. I ignore it. I'm like, the door is locked. They know, don't come in. I come, sit back down, go through about 7 or 8 more minutes on the Zoom call. Door gets knocked on again. I'm livid. Who is interrupting my Zoom meeting? It's something very important. So I go to the door, and I open the door almost like you open it, like you don't want anybody in. I'm like, what is going on? And the first thing, and I'm looking, and I don't even remember seeing the judge's face at first. I just remember seeing this black cloak. And at the same time I saw the black cloak, my stomach fell all the way down. And and I don't even think I said anything. I said something when I opened the door, like I'm on a call. And next thing I hear is, "This is my office." And I said, who would have thought that this was your? I said, "I'm completely sorry." And I started packing my things up, and I was not going to introduce myself, Missy. I tried so hard not to say my name.
Ma'am, I'm James Moore.
Yeah, that's right. Hey, I'm James Moore, man. Good to see you. So that was very embarrassing, but we made it through, and we actually have a good relationship now.
And here we are.
All right. Well, I'd like for us to touch on if there's any big cases out there that are of particular interest, and I'll start out. Healthcare has a lot of regulations and agencies that govern them. So there's a lot of agency actions that happens against healthcare providers, and the Supreme Court has granted certiorari in a big case that's going to address Chevron deference. So Chevron was a case that developed a doctrine that said if a rule that the agency is interpreting is ambiguous, then the court will defer to the agency's reasonable interpretation of the rule. And that has caused a lot of heartburn for a lot of years. So in Loper Bright Enterprises, that case, we're going to hear the Supreme Court, well, I should say we're going to see what the Supreme Court does, and if they tend to roll back Chevron deference just a little bit. How about you guys? Do you have anything you're watching?
Kevin?
And I'm famously strange for doing this. I watch one case over and over again, or one trial over and over again. That's the Johnny Cochran arguments, because F. Lee Bailey is my favorite, one of my favorite attorneys of all time. But I haven't. The last case that I was truly following was the Murdoch case out of South Carolina. And it was a fascinating case to observe. Now I'm really more so concerned, and what I've been trying to observe more is this development of the NIL landscape amongst high school students. And so I've been really following the regulations and what states have been doing with respect to allowing these high school students access to monopolize their name, image, and likeness.
Yes.
And so North Carolina has recently jumped on board with allowing that to take place for high school students. And so I'm curious, because you'll recall, and James will know specifically, when the NIL issue first presented itself to the collegiate level, it was there for a while and nobody knew what it was for a while, and we knew what it meant.
Right.
And so we had a difficult time of marrying what it meant to be able to monopolize your name, image, and likeness, and how exactly would that look in the college landscape. And so I think now we're approaching that same sort of landscape in high school athletics. And so I've been really following how that's going to present itself and where, our community can receive some sort of guidance, impact, and understanding of what can and cannot be done and how it can be sort of utilized to our high schoolers' advantage.
You are right. Education is going to be key there.
That's right.
James, is there any particular case that you're...
I would say generally the Camp Lejeune water contamination cases. Those are cases that we as a law firm are handling as well. I mean, we're representing hundreds of claimants that for various reasons were affected by the water contamination at Camp Lejeune. I'm passionate about this cause, especially given it's in our backyard, 45 minutes away from us. It's being litigated in the Eastern District of North Carolina. It's great for us in this law firm because I think most, if not all, of the lawyers here are already certified in the Eastern District.
Yes.
So we're going to be litigating those cases. Again, it's a great cause. It's unfortunate, the cover-ups and the lack of disclosure of what was going on at Camp Lejeune, the government knowing and failing to tell not only our military, but their families, even civilians. So that's going to be primarily for me for the next couple years. It's going to be something that we're going to be litigating as a firm. Hopefully I'll be instrumental in that as well. I think all of us ultimately will. But it's a good cause, and that's really where I'm focused now.
Well, that is just a wonderful segue to our guest that we have today. We are so lucky to have Shari Belitz with us. She is a litigation consultant, and she has a lot of experience in mass tort cases. For today's episode, we're trying to focus on trial preparation because there's an old saying out there that trials are really won and lost in trial prep. Although I do think the term trial prep, as we think about it, where we schedule, a month before the trial to put everything together, is a bit of a misnomer that, as I guess Shari's going to tell you, we should be prepping for trial from the start.
That's right.
And how we conduct ourselves. Shari is a great follow on LinkedIn. She is giving away nuggets of wisdom in the form of 80s parodies. And I am a child of the 80s, everything about it, from Dirty Dancing to Metallica. I love it, love it, love it. So Shari is here today to talk with us about some trial preparation techniques. Shari, can you talk to us about how you started off in law and how you made that transition to a litigation consultant?
Absolutely. Thanks so much for having me. So great to meet you person to person after corresponding for all these months on LinkedIn. So I also am Gen X to the core, if you can't tell by my music. And I started my career on a very traditional career path, as many people did who graduated from law school in the 90s. I went to a insurance defense insurance coverage firm in downtown Manhattan, navy suit, pantyhose, litigation bag, shepherdizing on the books, running in my pleather heels to file something at the last minute in court, no phones to be had anywhere except for the our landlines. So very different world, very traditional practice. So I was working at the firm, got my first big case in summer of 2001. It was really exciting. It was involving one of the companies at the World Trade Center. So all of our depositions were at the World Trade Center. We were what you called the rocket docket. So we were moving quickly, depositions every day. And we were there, 68th floor, taking deps every day. Right September 10th, I was at the Trade Center dropping off some papers because I was always running somewhere, dropping something off. It was like very typical early aughts. And I looked around and, beautiful view. And I just thought, wow, I'm really living the dream here. I'm New York City, no kids, having the time of my life, going to happy hour. And then I get back to my firm and a witness canceled for the next day. And everyone was in a tizzy. How dare he completely forget about what we were doing? We were the rocket docket. We needed to get through our depositions quickly. How dare this man be so careless and cancel the deposition?
Not on you. Not on you.
So fast forward, I still remember his name. He was an engineer, and he probably saved 9 lives of people who didn't show up to the North Tower, 68th floor that day. So after that, I had an epiphany of sorts and really just did a lot of thinking, a lot of reflection. It was a really hard time to be a New Yorker, to have lived through this trauma. And I said to myself, I don't think I want to be a practicing lawyer anymore at a law firm. I want to go back. I want to study psychology. I'm obsessed with the study of human behavior. I'm obsessed with the study of group dynamics. I just can't see myself doing this in 5 years, 10 years. I'm going to go back to school at night and get a grad degree in forensic psychology. So part one of the plan, I went to an insurance company, slightly more predictable hours, and I went back to grad school to pursue my dream and study forensic psychology. It was a long road from there. There were a lot of obstacles, like something that Misty and I have in common. I had my twins. Yes. There were lots of tumult, as we like to say, yes, in New York, and then began a career in trial consulting when my children were a little bit older.
That is fabulous. And, that's where Shari and I really connected. Is there's a special thing between twin moms. Well, let's talk about some specific skills. I think you have some really great tips, trial preparation tips that you can provide to our audience. Which cases do you think are the most difficult to prepare for, and how do you sort of embark upon that journey with somebody in those types of cases?
So there are so many cases that are difficult to prepare for, and every case really has its own difficulty. I would say that the cases that have, so first of all, the cases, I believe in really early preparation. I think you said this at the beginning, Misty. I believe that cases are not won in the courtroom. They're not won in our fancy suits. They are won in our sweatpants and just getting down and dirty and prepping our cases. So I think that the tough cases to prepare for, the tough cases to win are the ones where you're called in the night before. Hey, can you pick a jury? Well, you know what? Anyone can pick a jury. Can I see your file and see what we have to ask them in order to properly pick our jury? So those are the hard cases, just as far as preparation. As far as substance, I would say probably the most typical cases I get called in on, and a lot of them are high profile cases, are when there is a violent third party act on an insured premises, like a mass shooting, a sexual assault. I've done a lot of very high profile cases involving fact patterns like that. And the difficulty there is you have a lot of issues with liability can be completely defensible, but you need the jurors to really to get past that. The damages are often so catastrophic, and jurors will do something where they will fuse the two. They will fuse the liability and the damages and want to award something. It's also difficult as far as cross-examining the, these are very sympathetic witnesses a lot of the time, whether it's a sex abuse case, whether it's a shooting case, whether it is some type of act of violence. It's very difficult to really walk that tightrope when you're working on a cross-examination for a witness. Other difficult cases, I would say, are I look at a case as a book. And your books have a theme, and maybe there's a sub-theme, and each witness is sort of a chapter of that theme, and each witness advances that theme. And you really have to, I would say, of all of my services, and this is not in my pecuniary interest at all, because this is the grunt work, is preparing those witnesses for their deposition. Most bang for the buck. Prepare your witnesses for the deposition. I have seen more deposition transcripts when I'm preparing a witness for trial, and you're stuck with a bad dep transcript, and there are only so many things you could do. Get the witnesses prepared early and know how to do it and know what's important. So I would say that is the number one difficulty, not being able to prepare those witnesses and then jumping in and doing one of the later services.
So are you, as you're developing the case, and with always the idea of trial being in the forefront of your mind and everything that you do, are you suggesting that as quickly or as early as it's feasibly possible, you should be developing a theme that you want to sort of make its way through the juror's mind throughout the entire trial? And how can you do that effectively early in the case? Or is that something you just try to do once you get through, like you say, your depositions?
So that is such a great question. And it's very funny, because in a dream world, I would be on a case from the very beginning and really actually directing discovery towards that theme, or maybe changing up the theme depending upon what discovery reveals. However, that's not always the case. That's not always real life. That's not always in the budget. Sometimes I get brought in at a trial. I've often been brought in a trial where there's no theme that's written, and I will write the theme as I'm looking at juror questionnaires and I see who our jurors are. I can write the theme. But the best cases, the themes are written early. They are extremely flexible and can go with that developing discovery. But once you have that theme, those couple of sub-themes, and you don't need a lot, you really have a roadmap for your case.
That is so interesting that you say that, because I oftentimes laugh at James, because as soon as we get a case that we're going to be litigating, he comes into my office and he has the same theme for every case, and he says it from the beginning.
It applies in almost every case.
Kevin, it applies to every case. And he'll look at you square in your eyes with a serious face, and he'll say, "No good deed goes unpunished." Every time. But I love it. But that's interesting.
But in reality, Shari, we hardly ever use that thing. Now it has become just something funny where I've got it. Here's where we're going to go with it. But it is interesting you talk about that and when the best time is to create this theme, because I think as lawyers, we're all guilty of this. I'm not thinking of a theme until I hear, oh my goodness, okay, we've got a month before trial. I'm prepping and opening. I'm doing my directs and cross-examinations. It's now time to create a theme. Versus, I should have done that maybe when the case, not necessarily when it came in the door, but when I had enough facts about that case to go ahead and create this theme of how, if I am going to try this case, how it's going to progress. So that makes, I appreciate that, because I think a lot of lawyers are probably just like me, where
Well, it's hard.
they wait so late. Yes.
It's hard to come up with themes. I mean, because we're trying to craft the perfect theme.
That's right.
But Shari, I think I remember seeing you posting. There's a couple themes, like go-to themes that will work if you're just really struggling to, come up with one more customized for your case. Can you think of one that has worked in a lot of cases?
So my themes are they're very customized based on the case. And like I said, I could look at a file and a theme could jump right out. Like it could jump right out on an intake call. Sometimes it'll take a little longer. Sometimes we'll do a mock trial and the mock jurors will feed us that theme. We'll see what is important to them. And sometimes, like I said, I will write them at trial. So as far as what is a general theme that can work. So I like to look at cases as there are universal lessons. Themes are universal. They are universal right, universal wrong. So if you look at your case in a very broad sense, you can often extract that universal theme. So for example, take again these violent third-party acts on an insured premises, okay? Oftentimes, like let's take a sexual assault case, for example. Oftentimes it involves broken lighting or like something, there's a negligent security claim or, broken doors or broken locks or something like that. So what is the big picture of what I'm trying to do? I'm actually trying to unite the plaintiff in interest with the premises owner and show, look, we're in the same boat and we're against that violent third-party actor. It's not me against you. I might be the sued defendant, but believe me, I didn't want someone to come to our apartment and shoot up, and I didn't want someone to come to our apartment and start sexually assaulting people. So take, for example, a theme. This case is not about broken locks. It's about broken justice systems. So what you're doing is you're shifting the focus. Hey, I'm the landlord. I live there. I didn't want this to happen either. I am right with you, plaintiff. It is not about a broken lock. It is about a justice system that something went wrong there. And again, it has to make sense and reconcile with the facts of the case. But that, for example, is a very universal type of theme for that kind of paradigm.
Shari, how do you prepare direct and cross questions that are not too complicated for the jury to understand? I've found, especially dealing with medical types of stuff in healthcare, is that I'm always starting at the wrong point. I need to start much simpler because I'm 3 layers deep and I've done nothing to get them ready for that more granular information.
So, Misty, what I do to prepare for direct and cross is first of all, I look at them as two separate things. It's actually a bunch of separate tasks. So if I'm preparing my witness for direct, or often for the defense side, I'm preparing them for redirect if they're called as an adverse witness. So what I want to do is I want to do something that plaintiff's lawyers do in personal injury cases, which is plaintiff's lawyers get to know their clients. They get to know their clients years and years and years. They come over, they do a day in the life, they're watching them brush their teeth, get into a car, eating dinner with their family. They get to know them. I endeavor to do the same thing. I have time constraints often with my witnesses. I want to pull out their story and really find something just touching and beautiful and compelling. And whether it's a truck driver, whether it's a landlord, whether it's an executive at a company, a claims handler in a bad faith case, and I want to really get to know them as a person, because what I'm going to do is I'm going to pull that out on direct, because that is the way that I'm going to humanize the company. I'm going to humanize the big trucking company by finding out about what made the driver become a driver. What, tell me your story. So that's where you're going to get the really good storytelling on direct. And direct is one of the hardest things to prepare for because you really have to count on your witness for being the star. You really have to prepare them. They also have to have a cadence about them. They have to know when you ask that question, don't just answer it quickly. This is your time to really give your story. So when I prepare, for example, in med mal cases, doctors, nurses, medical professionals, I always find they have a very compelling story as to why they went into that profession. I get that story and we use that story on direct. And I practice with them so they know how much to say and really the cadence of how they're going to say it. So cross-examination, slightly different because I really look at cross-examination on television in the movies has always been portrayed as the gotcha, you can't handle the truth, that kind of narrative around cross. But really, that's going to be few and far between, impeachment, et cetera, few and far between. Cross-examination is the lawyer telling their story, and the witness is the puppet. The witness is that puppet. No one is going to remember if that witness is answering yes, no, I don't know. They're going to remember the story from the lawyer. So I prep the lawyer to tell the story. Then, like I said, it's a bunch of component parts. Prepping your witness for cross-examination, prepping your witness. Maybe they are called as an adverse witness, so they're asked a lot of leading questions, and then you're going to really get to tell their story on direct. So I really try to get an idea of how and when they're going to be presented and what is their objective. Ask yourself what's their objective, and then you go from there.
That's great.
I'm curious to know this because I've gone through various advocacy programs and learned from a lot of various, and I think great lawyers along the way. And
you can say names.
I'm not saying James Moore, but what do you suggest to your clients? And I'm talking specifically in relation to cross-examination about the tone and manner that the lawyer needs to have to the witness that they're cross-examining, because I've been in mock trials where I've seen people say, hey, I would like to have seen you get more aggressive or more blah, blah, blah with the witness. And I always found that I felt it was more effective and resonated better when it was more of a, hey, almost like you were doing earlier, we're all on the same team trying to make this journey towards justice, quote unquote. And so do you tend to advise your clients one way or the other on their tone and manners with respect to cross-examining? Or do you say, hey, if your thing is to go be a bulldog and run through the wall with a witness, then do that. And if your thing is to be kind, polite, and kind of compassionate with the witness, be that? Or does it really just vary on the case, depending on the case?
So that's a really good question. And also, of course, I give as much as I'm asked to give. Like sometimes I'm pulled into something and, I heard you have a very limited role. You're going to be here for jury selection. Then you're going home. And that's fine. I stay in my lane. But sometimes when a lawyer really wants to work on their advocacy or really needs opinions, I will help them with, I've written openings, I've written cross-examination questions. Like it depends how much they want me to be involved. So with respect to cross-examination, first of all, lawyer dependent. You have to be yourself. Even if you are parachuted into a case in a completely different part of the country and it doesn't feel natural to maybe use some of the colloquialisms or dress a certain way, you have to be yourself. So even when I hand off voir dire questions, I say, take it, throw it in the garbage can, or, take some of it, but do it in a way that is authentic to you. So with cross, so first of all, it has to be authentic to you. But second, it really depends on the witness. There are sympathetic witnesses, assault victims, children, just various kinds of people who have suffered catastrophic injuries, you're going to approach them different than you may approach a witness who you really want to extract an admission. So once again, I look at the witness on a case-by-case basis, and I look at what my objective is for that witness. If that objective, let's say it's a sexual assault victim and you are really not going to want to be aggressive at all, but what you do want to get is some things like a good way to, I don't want to say attack, but a good way to attack the credibility of a witness is not to attack the witness, a person. You want to attack memory. You want to attack bias. You want to attack all of these other things, like maybe there's something about the lighting or something about the timing or something that you're able to extract. Maybe they didn't see this so well. Maybe they didn't remember this so clearly. You're going to want to focus on that. So really, what I'm saying is, what's the objective? Do you want to get an admission? Do you want to show bias? Do you want to show memory problem? Do you want to show visual, that you had a visual advantage? What do you want to show? And then tailor yourself accordingly.
I really like what you're saying about being genuine. I think that is one of the things I didn't learn until a little bit later on. I tried to pretend to be other people that were great lawyers in their own respect, but I had to learn to be the best Misty I could be. Mm-hmm. I can't be someone else. So that really resonates with me, Shari. Well, you have really given us some great tips and techniques. We're going to switch to doing something a little bit fun. And we want to talk about the fact that lawyers are really quirky. We're really quirky with our office supplies and lots of different things. You'll see a lawyer in trial have all this stuff on their desk, and just like some of them are in right angles and crazy. But today we want to talk about our pens. I'm very picky about the pen I use. And so I have challenged all of us to come up with no more than 1 minute. James, I'm looking at you.
Might be a little long. No, might be a little long.
You have to we're going to use our persuasive techniques and our theme, and we're going to lean into it. I want 1 minute pitch for your favorite pen. You are on the clock.
I'm letting Kevin. Can Kevin go first? Do you mind if Kevin goes first?
I'll go first.
Look at him. He's
Tom,
scared.
If I can I get the 4-way picture on the screen? Because I want to see everybody's face as I shock them with this. This is technically off the off the hip, Shari.
Here we go.
Loosen up.
And you're gonna be the judge, and I want you to know that I've asked you the majority of the questions today, so I should get your vote for a winner.
Oh, maybe that's right. What's not going to get her vote. Kevin.
So let me get in my character. I've got in front of me a Pilot G2 0.5 ballpoint black pen. To the unassuming eye, it is simply an instrument you can use to display your thoughts. But when used correctly, it is a tool to the first-time home buyer that allows them to execute the document that secures their dreams. When used correctly, it allows the person who's just secured one of their largest deals of their lifetime to execute a document to guarantee their family's future. When used correctly, this is more than just a pen, James. This is a door opener and a way maker. This is a Pilot G2 .05 ballpoint pen. It's in stores everywhere near you. That has to be. That is on point, James.
Oh, very nice, Kevin. On point.
That's incredible.
You sold the story. You sold the story. Special moments of your life are executed with a pen.
Special moments, all executed with the ballpoint Pilot G2. I need that. I need them to send me them all they can, please.
Oh, okay. Shari, I want you to know there's been a lot of competition going on today between these two. There's been a lot of, I won't say the S word, but S word talking.
All right, I took some notes down for this because it's so important to me. And I'm going to direct this to Misty because Kevin knows where I'm going with this. Misty, with the exception of your reputation, What is the one thing that is unique and personal to you? What is the one thing that is the undeniable self-indication of you? Putting you on the spot.
Oh, I have to answer this
you-
question?
it's
I
not
didn't
ret-
know.
it's not
Okay,
rhetorical.
I know you got a pen in your hand, so it's clearly your name or your signature. We get it. Your name or your signature.
Fail.
Identify.
Misty, it's your signature.
It's my signature, James.
And the primary function of your signature is to permanently affix yourself, to bind yourself, to bind your likeness to something, whether that's a contract, whether that's a receipt, whether it's some other document. But it's permanent and it is personal to you. Now, what does it provide? It provides that you have permanently witnessed something, or you are certifying the content of something. It can even have value if it's an autograph and you're somebody that is important enough. And for the past 15 years, Kevin, I've had the privilege of using this pen in my hand to no fail. And for the past 15 years, this has become a self-reflection of me. This has become the unique, the personal, the undeniable self-indication of me. And I want to share that with you today.
Okay.
I want you to have an opportunity, Kevin, for this
We
pen,
have 1 minute yet.
for this pen to be unique, personal, and a self-identification of you. So I ask you right now, will you take this opportunity to use this pen?
I will take your Mont Blanc because it's a Mont Blanc, and I will keep it, and I have no issue with that. You know?
Okay,
I mean, it's not hard to sell a Mont Blanc. I mean,
I'm weighing
I sold
in on
something that's
this.
hard to sell.
You didn't even say the pen's name.
Yeah,
like,
no.
What kind of advertiser are you?
Well, I didn't want to say the Mont Blanc, but that's what it really is. It is a Mont Blanc. So.
Okay, my turn. All right. The Sharpie S-Gel. The S stands for smooth, satisfying experience while I'm writing. The sleek barrel and the comfort grip fit perfectly in the hand. You see, writing is more than a task. It's about an experience. The well-crafted tip allows the words to glide on the page and create your next work of art.
You were talking too slow.
Sharpie S-Gel.
I love it.
I love it. I don't know what. No, I would never buy Sharpie S-Gel. Would you like to give it a go, Sherry? Would you like to? Would you
You got
like to
a
try to
pen.
sell us on a pen on the spot?
What? Okay, on the spot. Why not?
Let's go,
I'm
let's
going
go.
to give it. I'm going to give it a shot.
Okay.
Okay. So I've selected my.
there it is.
My yellow highlighter. Okay, because all of the lawyers selected their pens. They write their motions, they write their ideas, they write notes, they write about the phone calls they take, and then their trial consultant highlights, cuts through all of the writing and highlights those themes that we have to sell to those 12 people.
That is perfect.
Like,
that is perfect.
love it.
That is perfect.
Well, you know, when I set upon, having us do this, I thought to myself, is the pen even still relevant anymore? Because we use computers every day. But I tell you what, I still handwrite my notes. I know it may be old
Same way.
school,
Same
but
way.
I still do. Well, it has been so wonderful having you on our podcast, Sherry.
Agreed.
I am going to use one of our techniques we talked about today. I should say we all are going to be to do that and create a vision board as we move through this podcast. And with each topic that we cover, like trial preparation, we're going to add those tips, those key tips that you fleshed out, of course, with your name there. And at the end of our season, we're going to have a wonderful vision board of key advocacy tips. So thank you for contributing to our vision board, Shari, and to our audience. Thank you for joining us. It's been a pleasure. And Kevin and James, do you have any departing thoughts for us?
Shari, I just want to say thank you so much for your time. I mean, the amount of notes that I took while you were talking is incredible, because I think they're going to be certainly beneficial for me in the future, and I hope other people. And I think this won't be the last time we talk, because I certainly believe you can be an asset to us, this firm, and what we do on an everyday basis. So thank you for your time today.
All right, everyone.
Likewise.
Oh, go ahead. Sorry, Kevin.
I mean, just cut me off. No, it's thoroughly enjoyed our discussion, Shari. It's been a pleasure to learn from you and gain some better perspective on how I can become and we can become more effective in our advocacy style. So I've heard nothing but great things about you from Misty, and then it's great to finally put a face with a name through discussion. So thank you again for your time, and hopefully we'll be able to chat soon with you.
Okay, everyone.
Well, thank you.
No, you go ahead, Shari.
Sure. I just wanted to thank you. Congratulations on your podcast. Thank you so much for having me, and link in and sing and learn with me.
Absolutely.
Oh,
Yes,
I
ma'am.
love it.
Thanks
I
to
love
Tom,
it.
too. Tom doing a great job. Thank you, Tom.
Yes, shout out to our technical person, Tom Peterson. Well, thank you for joining us on this journey to become the zealous advocate that you want to be. We look forward to joining you next time.
Thanks for tuning in to the Zealous Advocate Podcast. Make sure to subscribe to follow us wherever you get your podcasts.